Good morning everyone. This is Harini, Assistant Professor from BCom General Department. In this video, I am going to explain about the various important topic in the subject of company law. Before going into the topic, first we look into the meaning of a company. The word company is derived from the Latin word companies, which means a piece of bread together with piece of bread. First, a company is a legal entity which is formed by a group of persons in order to create a profit. In order to achieve the profit, every company motive is to earn the profit. So each and every company will be work towards the profit. So first we look into the definition of a company. According to section 220 of a Companies Act, the company means a company which is incorporated under the Companies Act 2013 or by the Companies Act with the previous year, which is a company law has been registered. Now next we look into the meaning of a company. Yes, I said earlier, the company meaning is a legal entity or an artificial person which is created by a law. A company is an artificial entity created by a law separate from its owner, which is the purpose of conducting business and sharing profit and losses. So every motive of a company is to earn the profit. So main characteristics, next we look into the main characteristics of the company. The company involves the main nine characteristics of a company. The first one is incorporated association, second one legal entity distinct from its member, third one artificial personnel, and fourth one is limited liability, fifth separate property, sixth transferability of shares, and seventh one perpetual succession, and eighth one is common seal, and last one is voluntary association. These are the main important characteristics involved in the company. With this note, we move on to the next. So formation of the company. So generally a formation of the company will be take place once after the registration of a company. So first, the company formation is a process of legally incorporating a business into establish it as a separate entity. So it has main four stages. The formation of a company, it took main four stages. First one is promotion stage, second one is the incorporation stage, third one is capital raising stage, and fourth one is commencement of a business stage. So next we look into the types of company. What are the types of companies were there in a company? So there are 8 types of a company. So let's see one by one. So first one is incorporated, and second one is liability, third one control, and fourth one transferability of a shares, and fourth one domestic and foreign company, and sixth one is one man company and family company. Next, last one is companies not for profit. So first in it, incorporation, it is subcategorized into loyal capital company, and second one is statutory company, and third registered company. Next we look into the liability. So at the liability side, so it has further classified into limited by shares, limited by guarantee, limited by the companies, which is unlimited. So next one is control, holding company and subsidiary company. So next one, transferability of shares is subdivided into two. One is public company and next one is private company. Next, we look into the meaning of a memorandum of association. Memorandum of association is an important document which is maintained by each and every company at the time of registration of a company. So let's see the meaning of a memorandum of association. In short, a memorandum of association is called as an MOA. MOA and AOA is an official document which is maintained by each and every company. Each and every company has to be maintained and has to be, at the time of registration, it has to be submitted. So let's see the meaning. The memorandum of association is a fundamental legal document, a company acting on its character and defining its relationship with the outlined world, and it outlines the company purpose, powers and limitations, essentially setting the boundaries of an operation. So MOH is generally will denote the rules and regulations of an outside of a company which has to be followed by its member. So the contents of the memorandum of association is listed here. The first one is the company, name of the company. Second one, address of registration of the company. At the time of registration of the company, we have registered the company name. So that has to be mentioned here, the address of a registered head office. And third one is capital structure of a company. The how much capital amount we have invested in the company has to be mentioned in that. So next one is the object of the company. Obviously the object is main important focus of each and every company. The objective is very important characteristics. So next one is scope of an operation. Last one is liability of its member. So next one is article of its association. As I said earlier, MOA is very important document which is maintained by the company, the same as well as the AOA is an important legal document which is maintained by each and every company. Let's see the meaning. The article of association is a key document that outlines the internal rules and regulations of a company. The MOA will address the outline of a company, but the AOA will be address the important internal characteristics of a company. So, internal rules and regulation governing a company's operation and management. Essentially, it is a rule book for how to run the company and to function the company internally, and also it details the procedure for thinking like a director, appointment, share insurance and decision making. In simple terms, it specifies the content of the business of a company and the document of the paramount significance of a company. So next we look into the prospectus. The prospectus is an important document the company has to be issued to the general public. Those who are investing in the company, the prospectus will be issued to the earlier members. The prospectus is a document issued by the company to sell shares. To sell the shares, the company will issue the prospectus to the general public to buy the shares of the company. So for that they will use the prospectus. It contains the information about the company operations, members, financial and purpose of issuing the shares. So the main objectives of the prospectus is to help investors to make important decisions before investing. Next one is quorum. A quorum is a minimum number of people required to officially hold a meeting and to do business. In meeting, there are proposals or voted on quorums. There are necessary check against small minorities and make significant decisions without the mandate. So, the quorum is the minimum number of the member to attend the meeting. If their minimum number is not present, the meeting will not be valid. So, first, it is the minimum number is required for the meeting. First one is 1000 members. So, if the company is having the shareholders of 1000, less than 1000 members, it has compulsorily the quorum members must be of 5 members. Next one, 1000 to 500 members, the quorum members must be present, at least 15 members has to be present the meeting. So, more than 5,000 members, the 30 members of the shareholders must compulsorily attend the meeting. So, next one is proxy. If a person is not able to attend the meeting at the time of the meeting, the person can appoint the subsequent or an additional person in the place of a individual. So proxy is an individual legally appointed to act on behalf of another party or the format that could allow the participant to vote without being physically present. If the member is not physically present at the meeting, the proxy will come and vote for them. So at the meeting, the shareholders who was not attend the annual general meeting, the AGM in short is called as a, so and the company may vote their shares through the proxy. Next one is prospectus. As said earlier, the prospectus is a document issued by the company to sell its contents, information and the company's operations, financial and purpose of issuing the shares. So next one is meeting. Generally we conduct the meeting to take any important decision. So in companies, a meeting is gathering of 2 or more persons for a specific specific person, typically to discuss and decide or to solve the problems. The meeting can be classified into board meeting, meeting of shareholder, meeting of debenture holders, meeting of creditors, statutory meeting, annual general meeting, extraordinary general meeting and class meeting. So the next one is annual general meeting. The annual general meeting will be conducted once in a year. So, annual general meeting is a mandatory yearly gathering of company shareholders and directed as per stipulated by the company law. So, it provides a platform for the shareholders to review the company performance and to take important decisions, and the matter will be discussed in the annual general meeting. So, next one is extraordinary general meeting. In the emergency case, we will not wait for an annual general meeting. In the emergency case, they will conduct an extraordinary general meeting. That meeting will be gathered by the company shareholder and it will be discuss and vote an important matter that requires the approval of an audit or removal of an audit in the regular of an annual general meeting. So next one is director identification number. It is an important number which is maintained by each and every director. So it is an 8-digit characteristics number which is given to the directors. So at the time it is a lifetime card validity. You can use the card by using this. You can be operated the DIN number at the various companies. So winding up of a company. So when will be winding up of a company? So winding up refers to the ending up of an operation of the company. By winding up, the company will become under the liquidation stage. At this stage, the company will be wind up totally. So it will be wind up by the court order or the judgment of a court. So winding up generally will be in the two cases. So compulsory winding up by the tribunal and the voluntary winding up. So voluntary winding up is subcategorized by two. So first one is member voluntary winding up and second one is creditor voluntary winding up. So next one is directors. So director is an important person in the company. So he is a director who is appointed to the board of a company tasked with managing the overseeing the company affairs. So the manager will see the company affairs, what are the company's activities are done. The manager will be, the director will be organize all those things. Next one is the managing director. The managing director plays a significant role in company management and the responsible of its expansion, profitability and the growth of an innovation. There are the senior level managers in a company looking after its day-to-day operations. They oversee the functions and performance of the different department. They obtain report from the department managers and turn report them to the executive and to the board of directors. Next one is legal position of the directors. The director will be act on the three positions. The director will be act. First one is it will be act as a, he will be act as an agent. Second one he will be act as a trustworthy and last he will be act as an employee of a company. So next, as a director, the company is a trustworthy. So first must have a good opinion about the directors. So next one is director as employee. As he is paying the salary, he must do his work as a proper way. So next one, powers of a director. There is a general powers and the specific powers, special powers. So in general power, he has to inspect the account documents and he has to give the notice of a company meeting and he has to give a remuneration. And last one is he has to attend the board meeting. Then the special characters, the special functions, issue of debentures, invest the funds of a company, make loans on behalf of a company. Thank you.